My name is Scott Griffith. I'm NACM Vice President. That's when I'm here. When I'm not here, sometimes I'm still NACM Vice President, but I'm also Director of Research and Court Services at the Office of Court Administration in Austin, Texas. Thanks for being here. I'm going to introduce these folks. Actually, I'm going to let them introduce themselves in a minute, but I have to share, some of you may have heard what Vicki just said, which is, this is a much more important panel than the last one, because look at the chairs we have. And the reason we have these chairs is because for the second time we're trying out a format that we may or may not continue with. The idea, and if we do continue with it, we got to think of a different name, I realize. Was billed as a fireside chat, which, you know, on a Monday afternoon in the middle of summer in Louisville, Kentucky may not really be the kind of thing that, you know, is very appealing. But the idea here is one that we think may work, and we certainly want your feedback as we go. And that's this. You know, we come to the conferences, and at least for me, some of the most important learning and sharing happens when we're out of rooms like this, when we're in the hallway, when we're having coffee, having a meal, maybe having a beer or something like that, and you have the opportunity to connect with people who you may only see once or twice a year, or people you've met only for the first time. And I find those interactions often to be among the most important that I have when I come to a conference. And so the idea here is to try to replicate that. So this ends up feeling, I think, something, at least it did when we did it the first time in Austin back in February. It felt a little bit like something between a panel discussion and what we call a SIG, a shared interest group, which is probably something like what it is. But the idea is to have a group of people assembled, a group of people who, at least in my opinion, and the opinion of the Conference Development Committee, are interesting people, and people who, if you don't know, you might want to get to know. I think everybody knows the person seated just to my left. So we're gonna try that. There's no script. We've met, shared ideas, shared some concepts, and I've shared with the folks here some things that I want to make sure we touch on. But there are no actually. There are two slides that I want to show at some point during our time together. But we also want this to be interactive. And I asked several people to join us this afternoon. I didn't know if they would be conflicted out from doing so, but I asked several people who I know to be smart, experienced, knowledgeable, outspoken, to be here, because we do want to have that sort of exchange. So something a little bit different. If you joined us in Austin, you have your own thoughts about whether that went well or not, but I guess the fact that you came back to this one means that maybe you thought it went okay. And it is something we want to continue doing if we get good feedback. I think that just about everybody knows Ernie Friesen, but you all may not know Vicki Carlson and Will Simmons. You saw Vicki up at the front at lunch today. Vicki's been nominated to be NACM Vice President. She works as a court administrator in a small-ish court in Minnesota. And Will Simmons, who's been on the board before and very active in NACM committees, works as a district court administrator in Georgia. One of the reasons I wanted the two of them here was because they represent two really different places, not only their courts, their jurisdictions, but also two really different states in terms of the continuum being unified. What I asked each of them to do is just say a few things about their work, their reality, and to also share with us, just for those of you who don't know them can get a sense of who they are and kind of maybe the way they think, is to answer, and Ernie will go from Will toward you. You can answer this question as well. If you weren't doing what you're doing now, what would you be doing? So we'll start with that, with some introductions, if you would.
Great. Thank you. Good evening. My name is Will Simmons again. I am a district court administrator in Georgia. Georgia is divided up into 10 judicial districts, and so I'm responsible for the 6th district, which is comprised of 14 counties and 20 superior court general jurisdiction judges. My day-to-day responsibility, obviously, is like yours. I have the alternative dispute resolution programs. I have bailiffs. I have court reporters, transcribers, budgetary. I'm the liaison to intergovernmental folks across the jurisdiction and other jurisdictions, so it's pretty fun. Been doing this for about 17 years. It's the only job I've ever had. When I graduated from undergrad, I began working for the U.S. Attorney's Office, and I decided to go to law school. And so I was there in Atlanta and at John Marshall, and I met a third-year law student who had been working in the law library of Cobb County Superior Court. And I said, hey, I could use a job in the evenings. And that was kind of my first big break. He gave me an opportunity to come to the courthouse and work in the basement. The cool thing was the treatises and the books there were the textbooks for the courses, so I didn't have to pay for anything. But I got a chance to know all the judges, because back then judges didn't, put in their own pocket parts. We had to do that kind of stuff, so it's kind of a grassroots type thing. But if I wasn't doing court administration, and by the way, like many of you, I stumbled on this. I didn't even know it existed. They didn't teach this in undergrad, but I stumbled on it, and I couldn't be more happier. But if I wasn't doing this, I could only imagine I'd probably be, I'm an education buff. I believe in learning, ongoing learning, so I'd probably be somewhere in a university giving some people trouble. Just probably, higher education in some facet.
Well, good afternoon. My name is Vicki Carlson, and I know this might be a little unprofessional, but I have to say hi to my kids because I might not ever get this opportunity again. So hi, Brianna, Andy, and Amber. I'll never get this opportunity again. It's live streaming. They're watching at home. This is their summer vacation. They're going to watch this. So get a little educated about what mom does. So like I said, I'm from Minnesota, and the reason I didn't raise my hand very high is because I didn't want him calling on me this morning. But I am proud to be from Minnesota. I'm from a court, and we have 6 judges, and just a little breakdown of Minnesota. Minnesota is broken out into 10 judicial districts. At each district has, I think similar to what Will described, a district administrator who manages those counties within that district. So I'm a local court administrator, and so that's who I really report to, is the district administrator, and then my judges, who I have 6 of those. My office is comprised of 30 people who work in court administration, and then each judge has a court reporter and a law clerk. So that's kind of the breakdown. We're a general jurisdiction courts. We handle all levels of violations and civil lawsuits and really everything. And then we're a state unified system, so we receive all of our funding from the Minnesota legislature. And so that really describes the layout of Minnesota. I guess if I wasn't doing this job, I always thought I wanted to be an accountant, and then I realized I don't really like numbers. Now, I know that's surprising coming from your treasurer, but I meant all day long. So that's what I thought, and actually after that I thought, I want to be a sign language interpreter. And they didn't have a program in Minnesota that was going to school nights, so I kept my day job, which was in courts. I got my big break in courts, similar actually to Will. I was 16 and is still in high school, actually working in the evenings, going to college, and on the Post-Secondary Enrollment Act, where you receive credits for high school and college at the same time. And I went to, one of my school counselors came to me and asked me if I wanted to work at the court, and I'm like, sure, making $4.30 an hour, yes! So that's where I got my big break.
Well, if I weren't doing what I'm doing, I'd look for another job, I guess. I've done that a lot of times. If you've seen my resume, you wonder why I couldn't keep a job, but I won't try to explain that. I think the most significant thing about my doing what I've done for a lot of years is that I started out as a trial lawyer in the U.S. Department of Justice, and I went around the country trying tax cases because they sent people out from Washington to do all their trials. And I was in 35 different federal courts. At that time, the pretrial conference was the biggest innovation that anybody was thinking about. The rule was simple. Rule 16 didn't have much to say about what happened, but every one of these judges had some form of a pretrial conference, and most of them weren't any good at it. They had no idea what could be done with it, but I remember that there were 3 of them who were exceptional. So when my wife insisted that she didn't want me to travel so much, our second child was born, I decided to leave and go into teaching. And I got a job at the University of Cincinnati, teaching civil procedure and criminal procedure and evidence and all the trial type courses. And the Ford Foundation came around and said they would give $10,000 to a group of professors to carry out a particular project. So I wrote up an application for a grant to study the pretrial conference, its procedures, techniques, and effects, relying on these federal judges that I knew. And I got a tape recorder, and I went around and tape recorded over 300 pretrial conferences because for some reason the judges trusted me to do it. And then I went back and listened to them and looked at the pleadings and decided what worked and what didn't work. And I concluded basically that there were a set of procedures that would work to make the whole trial go differently. Never forget what one judge said to me. He said, pretrial conference is not about a conference. Pretrial is an activity. It's a process to getting cases ready for trial. Actually, there was a book written about it in 1928 by a man named Mims that said the same thing. But anyway, I wrote this, and I decided that the thing wrong with the courts was that there weren't very many judges who knew how to do their work. And so when the ABA hired me to run the Joint Committee for Effective Justice, I made that a project to teach pretrial. And I got the pretrial judges who were good at it to come and teach it. And that's where case management started, in the pretrial conference. As a matter of fact, the first report on what we call case management was by the pretrial committee of the Federal Judicial Conference.
And Ernie, that's a good place for me to jump in, if you don't mind. No, you can hold that, because you're going to be talking again in just a moment. But as when you make reference to case management, and the other thing we had in the title of this session was retrospective. We probably could have chosen a better word, which, or at least to me, and I think, Ernie, you mentioned this earlier, for you as well, to me what that meant, or at least in planning for this session this afternoon, is just being reflective on what NACM has brought to me, what the things I've learned at these conferences, how they have found expression in my work. And one of the things that I did was, I know that many of you will be familiar with this. This is Bob Tobin's book. So this was, I'm seeing a lot of smiles and heads nodding. I know many of you have read this. So it was written in 1999, and this comes from near the end of the book, where the reference is, and the charge is dealing with leadership and the challenge for leadership. And one of the things that got me thinking about, because just a couple of months ago, I think many of you are probably familiar with this, Tom Clark and Victor Flango's book that just came out a couple of months ago. So we've got the unfinished reform, creating the judicial branch, the unfinished reform. That's 1999. Now I know we can go back decades earlier, and Ernie cited what was you mentioned earlier, you were telling me 1977? We were talking about reform in the judicial branch. We can even go back further than that if we wanted. But this is 2015, so that's a span of a decade and a half, and I know we can go a lot further. But it just, to me, it raises the question, and this gets to your wheelhouse, Ernie. With courts, the question is, so the more things change, how do you finish that? Is that true with us? I don't disagree with that, but so the more things change, the more things stay the same, or do the more things change? And so this issue of adapting and how adaptive we are as institutions is something that was really kind of rolling around in my head as we were thinking about this chat, and I'm thinking about conversations that I've had with colleagues like Vicki and Will, who work in states that are unified or non-unified, and to me it creates a really interesting context in which to consider how adaptive we are. And this is, this kind of relates to what our colleagues who were speaking in the panel just earlier we're talking about. The relationship between trial courts and state AOCs. And so I just took most of this language and just, hopefully that contrast is great enough with the red that you all can see it, just kind of reworked it a little bit. This is really nothing terribly new to many of you, but it gets at kind of what I'm talking about state and local strengths, reconciling who's leading, how do we communicate, how do we inform. So one of the things I asked Vicki and Will to think about is think about something big that's happened in your state or something big that the next big thing. How did it originate, local level, state level, and how does that work? And what are some of the challenges or frustrations? Anyone who knows Vicki knows that she's not going to wait around. If she has a good idea, she wants to get it done. And Minnesota, of course, just in recent years has gone to unified structure. So how does that work for you? How do you navigate all of that?
Thank you, Ernie. It has been a challenge. It's I've always said with unified funding and there's so many benefits. I mean, I want to talk about those first before we get to the challenges because there are a lot of benefits to the structure we have. We have the same court rules throughout the entire state. And I really have to look at, what the public expects of the courts. And it's a different perspective than I would have personally in the position I'm holding. But when you look at what the public expects, we have the same court rules throughout the entire state. We have the same court forms throughout the entire state. We have the same database throughout the entire state, and that means we have the same type of performance measures or pretty close.
And if something's wrong, it's wrong all over.
You're exactly right. So there are a lot of benefits to the unified structure. But I'd also say, to counter that, what we lose really is the customer perspective. When decisions are made at the state level, we lose what we're really trying to give the local customer. An example of that is everybody is, our fines go to collections. Department of Revenue handles our collections, and so that means our public can no longer come after their case has gone to collections and pay at the counter. Well, that's really troubling to me that we now have sent them somewhere else to pay a fine that they're coming to pay. And so we lose that local customer perspective when all the decisions are made somewhere else. So I really valued the discussion that was just held earlier with the state court administrators because it is really valuable. The number one thing they touched on was communication, and it's so valuable that we get that input. They talked about judicial counsel at this last session, and we currently have one court administrator throughout the state that resides in that judicial council. We have no local court administrator that resides on our judicial administrators and directors. And so we've tried to change that. I mean, I think we just need to keep having those conversations because I think it's important that we keep the local trial perspective. Did you want to say?
Sure. Well, it's quite the contrary in Georgia. Of course, being decentralized, I always wondered if the grass would be greener on the other side. I'm not really sure. But we have councils. We have a council of Superior Court judge. We have a council of state court judges, magistrate court judges, all these councils. And as of recently, the legislature just passed a bill and created the Council of Accountability Court Judges, which was formerly a function of the AOC. And so we've become a little more decentralized. And I, too, agree with Vicki that the previous conversation that we just had was about communication. There's two things that I found that will not change, whether you're decentralized or centralized. Number one, akin, is communication. I do agree with that. But while technology changes the way we do business, there's still the interpersonal piece that I think the court has to always be prepared to deal with when we deal with customers coming into the courthouse. There are some things technology cannot replace. So that doesn't change from being two types of systems either. But again, I would like to see, if you're in a decentralized state, one of the things I thought about would be regional meetings, whereby perhaps some folks from your AOC would come down to the districts. Again, we're 10. That's something that we hadn't really had a whole lot of in Georgia. And so there's this type of disconnect where everyone's kind of doing their own thing. The benefit to it is, as Ernie said, everyone's doing if it's wrong one place, it's wrong everywhere. The great thing about the decentralized system is that if a county figures out a good way to do it, most of us will come on board and figure out what that is. So it gives you the liberty to experiment and do certain things, and then if the other courts see that as something that's very beneficial, everyone kind of gets on board. But we're never all at the same place at the same time, which makes it a little difficult.
You really touched on creativity, and I think that's what you lose sometimes in a state unified structure, is that creativity. And so that was a good point.
I was headed in a direction when I started telling you about my research. Most of you are familiar with current movement in reform in the justice system. It's about evidence-based everything, isn't it? What's that about? Evidence-based means truth. That's what they're talking for. We're gonna make this decision based on truth for a change. And that's been around a long time. We just changed the name of it. I think that my contribution to this field is research. I found a method of learning about courts that no one else had done. I decided to go in and watch judges perform. I watched those 300 pretrial conferences and recorded them and studied them. And then when I went to another court, they had a problem with how long it takes to get a case to trial, so I went down and I counted all the continuances in the courtroom. There has not been a year since 1958 that I haven't gone to court and watched some judges and clerks work. I discovered about the problem in statistics, state statistics, by going and looking at things. I found a court that said they had 102 trials. 4 judges had 142 trials in June one year. So I pulled every one of those 102 files. Do you know how many trials there were that you and I would call a trial?
6.
4. Why? Because their definition of trials was written so they could tell the state legislature how hard they were working. Well, it had nothing to do with trials. The federal courts call every time somebody's sworn as a witness in the courthouse, it's a trial. And there are a lot of sworn witnesses that aren't involved in anything like a jury. Research corrects an awful lot of mistakes. And research is the basis of most of the good case management we have today. People who went in and watched it happen. There's a lot of bad literature about pretrial. People got court statistics and counted cases in the court statistics when the court statistics weren't valid. And then they said this is true and that's true. To me, there's only one way to find out, and that's to take a sample. And you go in and take a sample of 500 closed cases, you know what happened in that court for a while. How many continuances there really were. How many trials there really were. And all of those things that are the basis for making decisions. So I'm on my horse.
Well, no, stay there for a minute, because I have a question about that. One of the things that I told you I wanted to ask you was, what are we missing? And I asked this in the context of being familiar with your principles, and also just with this general, these general thoughts about how, just thinking through how adaptive are we? Are we? Let me go back to the prior slide, and I know it's behind you. You can't see it. Not unusual for ideas that generate in trial courts to suffer from parochialism and tunnel vision, just as it is not uncommon for ideas conceived at the state level to be impractical and trendy. That actually hasn't been my experience, but in any event, do you think that? What do you think of that? Do you think that's true? And is research something that we're missing? Are we missing?
Research is an essential element of that. There are many things tried out there in the field, and the best laboratory in the field are the field courts. Justice isn't in the state capitol. Justice is not in the Supreme Court. Justice is in all of the decisions, thousands that are made outside. The Supreme Court might make 200 decisions a year. And you've got not necessarily decisions, but cases processed that determine people's lives out in the field. So I think that research should be used to find out which of these experiments makes a difference.
You don't think we use it
And
enough?
research is a state of mind. It says there is a truth, and we can find it. But there's an awful lot of stuff published in the name of statistical research which has nothing to do with the truth. And so I think I would add a core requirement to everything that people have to have. They have to be not literate, but arithmetic. The court administrators need to understand real statistics, not the stuff you see in the newspapers about whether we need a new judge somewhere because look at all the number of cases we have pending, or how many trials we had last year, or how old the cases are.
So we're talking in part about culture.
Now, I have one last point to make on this one. The Federal Rules of Civil Procedure were a huge advancement in the history of man. They are now an impediment to access because lawyers have figured out how to make fortune running the Federal Rules of Civil Procedure. When they came in, and for about 15 years, and I lived in that era, they were very valuable to bring about justice. Where did they come from? Any of you know? Well, they had a group of people from all over the United States that brought in the rules they had in the states. Every rule of the federal rules existed in a state before it was there. The pretrial conference came from Michigan. A judge in domestic relations cases didn't like the trials he was running. He said he never knew what was going on. So he called the lawyers in a week ahead of time to find out what it was all about. And his calendar improved overnight by going through the process. He wrote that up, and he told a professor at Michigan University. And the professor was a famous judicial administration man named Sutherland. And he was on the committee that wrote the rules. There wouldn't be a pretrial rule if Sutherland hadn't dealt with a domestic relation judge beforehand. That's what we're talking about, this idea that everything does originate out there in the field. It needs to be evaluated, and that's why research is the top of this spread. And if we centralize all wisdom, we're going to lose it. We lose the wisdom that comes from individuals working through problems in the court system.
How wise do you feel most days, Vicki?
Not very.
What's your take on that? I mean, I know you're a fellow. You've been through that. You've had all that training. Do you have time? Is there a demand on the part of your bench for that kind of approach?
Well, I think we have that approach. I mean, I think we take that approach right now, and we have some, early, especially in our dissolutions, we have some early case management type things that are really helping to solve these cases before they become very, before they go to an actual trial. So I think we're doing a really good job of that in Minnesota.
But how do you collect that information and get it to the center where it can do some good for other people?
Yeah, and that part is difficult because some of it, it's still hard to collect how many hearings you're having to get these to a resolution and not a trial. And I don't think we've perfected that yet.
What about in Georgia, Will?
Well, interesting. We're going through that right now. In fact, on Friday, I received a letter from our research department at the ALC that 2 of my circuits did not qualify for a new judgeship, which is what Ernie was just talking about. So case in point, about a month ago, I had one of my circuit judges, he was pushing me to have a circuit judges meeting because he felt that he was working hard, but for some reason he was always behind. And it's a 4-judge circuit. And so I knew that the other judges were caught up. Like they were on point with where they should be given that year. And so what I did, because he kept pressing me for this meeting to ask so we can formally request a new judgeship study, I went to the docket and I pulled all the numbers, the research. And what I found was astonishing. And basically Court Tools, which came from the National Center. I just kind of look at those numbers. And what I found was that he simply was not trying cases as on pace with the other judges. And so instead of calling a meeting and knowing that information, I had a candid conversation with the judge and showed him the data. And as a result, I think it's helped him. So again, Ernie's right. The research actually leads you to what the answers are on the local level, whereas I could have easily probably gotten a fifth judgeship.
Let me open it up at this point. Let me take a break. I know several of you in the who are here today don't shy away from numbers, are perhaps drawn to them. Critical thinking in your job. What do you think? What's your? I mean, it's almost as if we've been issued a call to arms. I think, Ernie. I don't know if I'm reading too much into your comments there, but what's your sense? Everybody, anyone have any thought about that or a response to it? Anyone want to pick up arms and follow along?
Well, Scott, I'll say, being from Georgia, like Will, it's a challenge to get our judges and other judicial branch executives and laypersons, so to speak, to take the feelings out of the work and to research or drill down into what's really going on at the local level, whether it's by circuit, by city, by county, because we have all types of levels of court in Georgia, to really identify the core issues that are having an impact, negative or otherwise, to the ebb and flow of the judicial processes. Like I said, we'll have judges who will feel like they're doing so much work. We'll have staff that feel like they're doing so much, but when you actually look at the raw data or the numbers, maybe they're on par with everybody else. Maybe they just, I don't know, maybe they just have this, they're less tolerant of the stress and pressures that come with the day-to-day grind in the courthouse. But we have a lot of that and trying to get people away from that. And when you talk about research for a number of judges and a number of staff, that's a problem. They don't want to hear about that because, oh, we don't, those numbers aren't really going to tell you what's really going on. Like I used to hear that when I worked at the AOC in Georgia. Oh, well, those numbers, that doesn't really tell you anything. And
because you're not collecting the right numbers.
That's probably true. That's probably true. So that's just a challenge that now with me working in local court, having worked in local courts now, my first thing is the data. Let's look at the numbers and not just outputs. There are other factors that need to be taken into account when we want to make large-scale decisions, especially like Will was talking about, seeking additional judgeships, because there's a lot of scrutiny that comes with that because a lot of money follows that. And anytime you're talking about money you're taking of money, you open yourself up to the additional scrutiny that a lot of my superiors and others don't really want to have anything to do with. So.
I was just thinking, Edwin, as you were talking about, cases and collecting stats, and I was thinking about, in my court, our timing to disposition. And, we're not meeting our Minnesota standards right now on getting our criminal cases through the court. And, talking about statistics, yes, we're collecting how many hearings we're having, how many continuances, but we don't know why. So as we look to go to a new calendaring system is what we're trying to do in my court, and eventually I think some of our judges want to go to blocking because we're not in a blocking system. It raises the good point. I've actually taken 10 of these cases at random to specifically look through them individually to see why are these cases getting continued. That's one thing we don't collect. We don't collect, what's the reason behind the continuance. We know that there's been 3 hearings in this case or 5 hearings, but we don't know why. So we might be collecting the wrong data.
I was doing a consultation in the country of Jordan about 5 years ago. And what I did was say, you've got to change and keep track of the reasons given. I don't care what they give you, but whatever you write down, that's what we'll take as the reason given. The backlog in cases was reduced by over 3/4 in the course of 6 months when they started collecting the reasons. And it's what you count affects behavior. If they know you're keeping track of the appearances, they've got to come up another way. You want to know something? The lawyers will figure out another way, and then you've got to be ahead of them.
So if this is something along the way that as professionals that we've missed or we haven't sustained, we haven't nurtured, a couple of questions. One, when did we go wrong? And how do we fix it? That's a question for the folks up here, but also folks out there who might have something to say about that.
Well, there's been an awful lot of bad research, and when people can't trust the research they have, they don't do something. I remember one study that was done recently that compared, not recently, it's almost 15 years ago.
About the time this Tobin's book was written.
Yeah, and it was done by some friends of Tobin's. Yeah, but they compared the number, the method of trial and the timing in Massachusetts and compared it with Kansas City and Phoenix and didn't explain anything at all about the difference. In Massachusetts, they had a mandatory arbitration rule that had a huge impact on the system. In Kansas City, they had a different rule, and they were comparing apples and oranges in the classic sense of the word. Now, I know a lot of people read that and said that can't be true. Well, the reaction is to not to trust research. And my experience with an awful lot of the research was it's not trustworthy. You don't become a researcher just by going to law school, that's for sure. Or even trusting, because lawyers don't trust evidence very much. That's why they spend so much time trying to find a contradiction of evidence. That's their job. But there is a state of mind that I think should be added to there's I don't have time. I have one more thing I want to say that changes the subject. I think in your core requirements about what court administrators should know, you have due process of law. It's written in there if you read them carefully. You need to understand due process. Something else you need to understand is remedies. You are dealing with all different kinds of remedies. As the judiciary of the United States becomes more and more a social force, becomes a part of the social structure of correction. It wasn't that in 1960. As it changes, you're going to need to be able to understand what courts can do. It's not just damages or jail. They can do a lot of other, and they're doing other things in all these fields. So we need to add to the core the understanding of remedies. And you don't understand remedies unless you understand equity. Because so much of our law, the lawyers, the people who have studied law know how equity and law originated separately. But it's not just law and equity. There are the whole masses now of remedies, including the original writs, which is a third kind of remedies. So you who know something about it, don't you agree with me?
Do we have any judges in the room?
Got a lot of lawyers, law-trained people.
I'm just wondering, anybody have anything they want to say about talking to judges about these issues and strategies that have worked I'm thinking about Will, about your example. I mean, my experience generally, not completely, but generally has been that when you're talking about issues of research, numbers, that those issues often get pushed to the end of the agenda and rolled over. And tell us, if you wouldn't mind, who you are, where you're from. Just so
Matthew Pendy from Franklin County Municipal Court in Columbus, Ohio. One of the things I did after I graduated from the fellows program was I went back and I tried to implement something similar to where you were tracking the continuances. Well, I set it up with one of the judges, my champion, because I knew he'd do it. And we got into it, and it kind of faded slowly. The biggest concern was that it was going to be public information. So in order, and I talked to a few people in the court, and they said, don't try to do all of them. There's 15 judges. So try to do one and see how it goes. Well, it didn't end up turning out. There was 5 criteria. I used 5. I said, I want to do these 5 things. And it turned out he only ended up using 1. So he used 1 only, and now there's 8 cases a month that he looks at for pretty much the whole program. So I wanted to try to do it full scale, but it didn't really work out that way. So.
I just have a question for you, Scott. As director of research in Texas, what can you do? If you have, there are 400 plus counties in Texas?
254.
Oh. And they all do things differently. And they all have different systems, recording different data. What research can you do?
I can give a partial answer, but I'm looking at the back row. I've been in Texas for all of 11 months. Bob Wessels can answer that question.
Bob did some great research in Houston, but that was Houston research.
One of my first NACM conferences, and Bob, I know you've presented at many, but I think it's probably more important that you hear Bob speak. But one of the things I want to say is that I'm not sure in the state where I'm in, or the state that I left, where I'd worked for a number of years, that was Louisiana, that we did a real good job from the AOC in really making it clear why the information mattered, what we were going to do with it, and why it mattered. So what we got is submissions that were data that was submitted to us without a lot of I want to be careful here because the submitting entities were folks by and large who were being dutiful and they cared about what they were sending in. But what we often found were errors, oversights, and I think one of the things we could have done to correct that is do a better job of explaining why it mattered and how the data were used, and maybe most importantly, have a really clear agenda for how we were going to use it. So that's one thing, is setting an agenda. But Bob, you have a whole lot more experience in Texas than I do.
Well, first, let me go back to something you said. I don't know so much that it's anything we've done wrong. I think it's something we've lost. And that's our curiosity about how cases do go through the system. When I started, one of the things that was fundamental was every case had a reason for a setting and a result of that setting that we tracked and track today. In fact, now, if you look at a reset form that's used, at least in Harris, there's a reason for a continuance, result of the contingent. They charge it up. State didn't have their information. Police weren't available. Mental health, all the various reasons. But the fact is that if you do that, it seems that as case information systems moved along, we got very fixated on processing, and we dropped the counting part. And we got lots of macro data, but very little data about individual cases. And that's where it all starts. And that's what makes it real to a trial judge or a court coordinator or somebody in a courtroom. What do I need to know about that individual case to move it along? How old is it? And I never used age of case. I used days old. And if you go look at a judge's docket today in Houston, you will see for every case that's on a docket or calendar, it says days old. Why? I wanted to reinforce the notion of old. You then have the number of appearances, and some other information. Are they in jail or not? If they are, how long have they been in jail? And just little quick pieces of information that a judge who's calling a calendar of 50, 60, 70, 80 cases can quickly look down, doesn't have to pick up a file. And when you provide that information, first thing half are going to say is, I don't need it, I don't use it. Well, it doesn't cost me anything to print it, so we just kept printing it. And over time, what happened is the judges started relying on it because something about a case made them stop and think, this isn't reasonable. Why have I got a DWI that's 365 days old and 15 court appearances? This is stupid. And the judges began to get into that. We also, every report we ever ran, we put every court on that report. And over time, I called it the mad dash to the middle because no judge wanted to be on either end of the spread. And it started lots of conversations about, well, how did you get there? Why have you got 300 cases set for trial and I've got, Judge X has got 60? It got a conversation going. It gets back to this point of curiosity. Now, to Texas and to Scott's point, I hope that we are, with OCA and Scott and David's leadership and Casey Kennedy, that between those three folks, we're going to get out of submitting by county gross case numbers. For Harris County, you had 10,000 cases filed, you disposed of 9,000. That doesn't tell anybody a blessed thing, other than somebody could figure out that there might have been 10,000 and maybe there were 9,000 disposed. We need to get down to the individual case data, start reporting that way to the Office of Court Administration based on standard definitions, and then let OCA, or in the office that I ran, a research department, massage that around in a warehouse and begin to look at what is going on and produce some information that has real meaning. And more importantly, is defined the same way. The problem in Texas and many other states is you send information up, but the way it was prepared or aggregated at the local level is different depending on which clerk did it on that particular day. It doesn't even matter the county. It depends on which clerk actually prepared the data. Well, people know that. Judges talk about it. So what happens over time? No one cares about the data because they have no faith about the data they sent in, and they assume that everybody else in the state isn't doing it much better than they are.
Well,
so nobody looks at it.
And that gets to your point, Ernie, about losing faith, and I think you end up in sort of a kind of a downward spiral there, and it does take some real intention and some real effort to get out of that.
But if we started, all of us started doing based on common definitions and sending case level data to either our local administrative office or our state administrative office, and then began to apply standard definitions either within the state or across states, and I realize that gets a little tricky. It is amazing what we could find out, and maybe some of the things that we thought were really bright ideas might not have been so bright, and maybe some things that we discarded years ago, maybe we should take a second look at.
Norm, you wanted something really good?
I'm Norman Meyer. I work in the bankruptcy court in the federal court system in New Mexico. I've been in the federal courts for 26 years, and so some couple of things that Ernie said kind of like, ooh, feds. But one thing Bob just said, Bob just used the term warehouse and analytics and that sort of thing. And I do a lot of things in IT, and one of the big trends sort of worldwide, that's a revolution that's happening, is big data and analytics at the corporate level. I mean, it's what Google does to the max, for example, with the data that it collects on all of us every minute. But the courts, I think this is a revolution that's happening within the courts too. And if it isn't happening in your state, it's gonna. And I work in the feds, okay? And so let me give the feds example. We have a case management system that we've been using for some time. It's called CMECF. It's basically replaced just the standard old dockets and that kind of stuff. Well, the next generation of CMECF is being programmed right now. It's called Next Gen. Oh boy, good names. It's going to take a while to roll out. It's very complicated in many ways, but one of the key tenets of that system is identifying all the different things that happen in a case and assigning data elements to those things, which we didn't do before. And so we're going to have this rich warehouse of data that'll be there to enable research at whatever micro level you want to dive down at the case level, by the judge level, by the district level, by the region level, whatever level you want to do.
And will you have access to that in your court, or is that all happening at the?
Yes, and so that's one of the neat things about it is that the database is a locally housed, generated thing that we have access to, and I can hire my own analyst or whatever and look at it if I want to, or I can rely on the FJC's research division or the AO or whatever, or the circuit level. But the data will be there, and it is accessible at the local level. It's one of the myths about the federal system is that we're so totally decentralized, and then we all say, bow down to Washington D.C. in the morning. Well, the federal courts are much more decentralized than you think.
No.
But my point is that the revolution is happening in terms of data analytics and being able to do the kind of research to dive down and gather the data. The data are going to be there.
So long as you don't let them redefine terms to look good.
Yeah, I mean, obviously there's a policy thing and implementation question.
The beauty
but
of
I
the
think
federal
the opportunity is
information
there.
system, it was designed in the beginning and nobody was afraid of it. The Table C and the Table Ds of the civil and the criminal divisions have been kept consistently for many, many years. And historically, if you understood what they were counting, you could get a lot of. It was the only court in the country where you could find out when a case left the system, at what stage. Some of you know that I originated the reverse telescope. It was to make this point. Cases don't go to the end, they go out at different points. And if you start with some other assumption, you're going to be wrong. Case management, though, has got to discover unmanipulatable data. Some years ago, I found out that jury statistics were probably the best you could get to find out what was happening in a court, because the jury commissioner didn't have a separate set of definitions. There was a trial to a verdict, or there wasn't, or they convened a jury and set them in. I'm just using that as an illustration, and I agree with you so much. You've got to find those common things that are reported routinely, so they're true.
Will.
I just want to piggyback off of what Bob and John said. We have 159 counties in Georgia, so that means we have 159 elected clerks of superior courts. And every day I leave the courthouse, I'm becoming more and more keenly aware that as the administrator, if I'm not the bridge between the judge, the clerk, and the AOC, we will never have true research. Do any of you all, how is your clerk's relationship with the AOC? Because the data comes from the clerk's office, who's the keeper of the records, and it's coded differently. We all have different systems, and it's sent up to the AOC. And the disconnect and the not so good relationships come from they're not speaking from the same terminology, and the data is produced differently. And so I'm stuck in the middle, and I got to figure out how to. I have a good relationship with my clerks, but my clerks don't have a great relationship with the AOC. It's communication again all over. So how many of you are in that situation? If you are is there anything you would suggest that can be done to probably make that a better relationship? How many of you actually face that reality? Okay, all right.
Well, what we did is when we implemented the data warehouse, we took the burden of reporting off the clerk, and they loved it. We created years and years ago in Harris County uniform definitions. one day we were in a meeting and I asked a simple question. I said, how many DWIs were filed last year? And I got 6 different answers, depending on who was counting them and all the other issues that everybody knows. So we got everybody together and said, well, how many other occasions did this occur? Everybody said, this is nuts. You know, we need a single version of the truth, as one of my staff members used to say all the time. And so with the data warehouse, we began producing the reports based on uniform definitions. And it was the uniform definition piece that got everybody engaged, because everybody saw that today it might help you, tomorrow it might hurt you. And if you took the game playing out of how those numbers were created, it put everybody on a little more level field. Well, the only thing I can say that's really different between Georgia and Texas, we didn't stop at electing 1 clerk. We elect 2.
We've got just about a minute left. Is anyone wanting to make a point that they haven't been able to? I'm glad you brought it up, Ernie, because this is a helpful discussion. And John, your question's a good one. I see several people in the room. Margaret, you're one of them. For those of you who don't know Margaret Allen, her day job is Director of Judicial Education in Ohio. Okay, but you're also in the NASG. Right, and so I don't think we have any judges in the room, but this is a conversation. Your point's a good one, and Bob, at some point, maybe in a minute or two in the hallway, I might like to ask you how it was that not every administrator, not every court manager has the same standing in their court with their judges as I think you did. That's a discussion for another session, but I think it might be a good discussion to have. So. Anyway, thank you all very much for coming, and thank you to Ernie and Vicki and Will. Thanks very much. Last session of the day, so off you go.